You're listening to the Cyberwire Network, powered by N2K.
Hey everybody, Dave here with a quick request. If you could leave us a review on whatever platform it is you listen to this show, it'll help spread the word and grow our audience. So please take a few minutes and share why you think this podcast is a valuable part of your day. Thanks. Here's the show.
The number one responsibility of the U.S. government is to protect itself. Before the U.S. government starts telling the private sector what it should do, it really should stop living in the glass house, where its own cybersecurity is literally much worse than most private sector networks.
Hello, everyone, and welcome to Caveat, the CyberWire's Law and Policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Health and Homeland Security. Hi, Ben.
Hi, Dave.
On this week's show, I've got the story of a photographer who came up short in an online copyright claim. Ben wonders if the Supreme Court is going to take a look at the Computer Fraud and Abuse Act. And later in the show, my conversation with Dmitry Alperovich. He is the co-founder and former CTO at CrowdStrike, and we'll be discussing the recently published Cybersecurity Solarium report. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. We'll be right back after a word from our sponsors. This episode is brought to you by Palo Alto Networks, the leader in cybersecurity. As AI-driven attacks increase, organizations can't afford to have network security that's stuck in the past. Discover how Palo Alto Networks can help you predict what's coming and proactively secure against it with a zero-trust, AI-powered network security platform built to secure whatever, whenever, wherever. To learn more, visit paloaltonetworks.com/network security platform. And we are back. Ben, before we kick things off, we have a little bit of follow-up.
Uh-oh.
We got letters, Ben. We got lots and lots of letters.
That can't be good. Letters are not good.
Well, they were friendly and they were kind letters, but many people wanted to point out that a couple weeks ago we talked about the concept of force majeure, and you pointed out that, like many things in the legal system, force majeure is Latin, and our kind listeners let us know that no. Or I should say, no. Force majeure is French.
Yeah, let's just say I was testing all of you guys to make sure you were listening. How could a word like monsieur be French? I just have no idea.
How could it be anything but French?
I know. Yeah, I don't know where my head was. Just let's blame it on the pandemic and
I say
lack of
we'll
sleep.
Move on.
Yeah,
take your lumps and move on.
Exactly.
All right.
But if you want to send hate mail, to our lovely podcast,
I don't know.
I'm happy to accept it. I will eat crow on this one.
Yeah, maybe all your students should get 10 bonus points for the professor making a mistake like this.
They probably deserve it after this. Yeah.
All right. Well, thanks to everybody who wrote in. We do appreciate it. Let's move on to our stories this week. My story is an interesting one. This is a copyright story. A court ruled recently that Mashable can embed a professional photographer's photo without breaking copyright law. And this is all because of Instagram's terms of service. So this court in New York, this is a district court in New York, determined that a woman named Stephanie Sinclair, when she posted her photos on Instagram, that meant that other people could embed those photos because Instagram has an embedding function like many things online. And basically, this court is saying that she gave up her rights to those photos for other people to embed them. She lost control over whether or not people could embed those photos or not. What's your take here, Ben?
Yeah, so as soon as she decided to post the photograph on Instagram, she forfeited her copyright claim because the Instagram terms of services say that you are granting Instagram a sublicense to use the public content that you post for the users who share it. This decision from the district court came from Judge Kimba Wood. Those of you who are 1990s historians might remember that she was Bill Clinton's first attorney general nominee, I believe. So she's a pretty prominent judge. And the decision seems relatively simple to me. This is a terms of service issue. It applies specifically to Instagram, and it means that there can't be any copyright claims when another website embeds an Instagram photo. One interesting argument that this photographer made, who initiated the lawsuit, is that Instagram sort of owns the market for the sharing of photography. And, she's a photographer. If she wants to share her work and she wants to retain that intellectual property, but she also wants to get a wide audience for her pictures, she's going to post them on Instagram. And she really doesn't have any other choice. That is the photo sharing application. What the judge is saying here is, yes, I recognize that. Yes, they have the largest market share. And I recognize as a judge that that's a very difficult decision. But this is ultimately the decision you made, Madam Plaintiff. You decided to post this photograph. And as soon as you did, you forfeited your copyright claim. So in the exact words of Judge Wood, the plaintiff made her choice.
Yeah, this is interesting to me. A couple reasons. It reminds me of back when YouTube was brand new and was just sort of getting up to speed. I think this was back in the 90s, I suppose. There was a lot of concern, a lot of gnashing of teeth and wringing of hands over whether or not, if you uploaded a video to YouTube, if you gave YouTube all the rights to your video, and they could use it for anything. They could sell it. And of course, these days, it's impossible to imagine a company, for example, not uploading their corporate image video to YouTube. It's become a standard thing. And it seems as though many of those concerns didn't really play out. But this reminded me of that.
Right. And I think Instagram now plays the same role in the photography market that YouTube played in the video sharing market. In other words, for marketing purposes, whether you are a photographer like this plaintiff was, or you are a company, you are going to need to post on Instagram to reach the largest number of eyes. And it's sort of a public policy problem that you will not have any intellectual property rights once you put that image on Instagram. If there were an enterprising company that came along and said, well, we're going to be the photo sharing company that will protect your intellectual privacy rights. We're going to prohibit embeds. We're going to say that there is not a transferable sublicense to that photo. Maybe that company could increase its own market share and give a competitor to Instagram. Do I see that happening? Not really. I mean, Instagram is so prevalent in our lives. Most of us wake up and check our Instagram stories, and we're sort of stuck with the sub-licensing agreement that they've foisted upon us. And given their large market share, there's unfortunately not much we can do about it. And I think what makes this case interesting is we're talking about a professional photographer. So she doesn't retain the rights in her own professional work. I mean, imagine that in any other context. If I wrote some sort of policy paper and, I had all these original ideas and it was so brilliant, and as soon as I saved it as a PDF, then anybody in the entire world could embed it on their website without attributing it to me, or, giving me a copyright claim. I would not be very pleased with that.
Well, and I wonder if Instagram could provide some more control here. If you could have a pro level account, maybe charge a fee or something where someone can share their photos on Instagram, but that's it. You can choose whether or not embedding is active on some sort of basis per photo or per account or something like that, and maybe pay for that privilege.
Right, exactly. And we see those types of privileges on a bunch of different types of online services. I think of LinkedIn Pro, where I, of course, want to see who has viewed my LinkedIn profile, but I don't want other people to see that I've viewed their profiles. So I can pay for the privilege of knowing who's looked at my profile without sharing which profiles I've looked at. Perhaps Instagram could do something like that, where you get Instagram Pro, and you can opt in or opt out to the embed function. I mean, I think that might be the most equitable solution here. I think what the court is saying is that's a solution that Instagram will have to come up with if it becomes a big enough problem for its user base or its customers. But that's not a problem that this court is going to solve.
I see.
So, I think it was sort of passing the buck down to the private organization in this case.
Right. You made your choice when you signed up and agreed to the EULA, which we all read word by word, right?
Absolutely. Yeah. We all spent 10 hours reading the 600 pages of the Instagram terms of service. And then we were so bored with it, we didn't even want to post any photos. But
right.
Exactly.
Right. Yeah. All right. Well, that's my story this week. What do you have for us, Ben?
My story comes from the publication Reason, and it is from Professor Oren Kerr. Frequent listeners of this podcast probably know I'm a bit of a fanboy for this professor, but he is one of the foremost digital privacy professors out there, so I take what he says very seriously. And this is about a potential Supreme Court case on the Computer Fraud and Abuse Act. This act was passed in the 1980s. It was a pre-internet piece of legislation, and the primary purpose for the act was to prevent the sort of hacking that existed at the time, which is obviously very different than the hacking that exists in the internet age. And there's been a long-running disagreement among courts as to what exactly the Computer Fraud and Abuse Act does. What does it mean by unauthorized access? So there's one strain that basically says unauthorized access means somebody has stolen a password or gained unauthorized access through nefarious means. They've literally hacked into it, or they've broken cryptography. Okay. That's sort of what one set of courts has interpreted. And that's more of an originalist interpretation of this law, because if you look at the legislative history, that seems to be what Congress was trying to prevent. The other strain of thought from different judicial circuits is that it can be a violation of the Computer Fraud and Abuse Act if you violate a website's terms of service. So even if you didn't hack into the website, even if you didn't break their cryptography, you just use that site for a purpose that is not authorized according to the terms of service, then you could be prosecuted under the Computer Fraud and Abuse Act. So there's this case that has made its way through the court. It's actually right now in front of the Supreme Court. They're considering whether to grant certiorari, whether to hear the case. It is Van Buren v. United States. And the justices finally have the opportunity to resolve this circuit split. According to Professor Kerr, the court is likely to hear this case, and we should find out in the next few days whether they've decided to hear it. Just a little bit of background on the case itself. So Mr. Van Buren, it's not the president, nor is it the Van Buren boys of Seinfeld fame. He was a police sergeant. He ran a search through a police license plate database, but he didn't do so for, quote, law enforcement purposes. He did so to search for a cash payment from an individual working as part of a police sting. So it was an unauthorized use of a database. He was charged under the Computer Fraud and Abuse Act, and he was convicted. This was appealed to the 11th Circuit. The 11th Circuit affirmed the conviction on the Computer Fraud and Abuse Act because it was the 11th Circuit, one of the judicial circuits across the country, that has held this interpretation that any violation of the terms of service of any sort of database or any unauthorized use of a database that somebody already has permission to be in violates the Computer Fraud and Abuse Act. And Professor Kerr seems to think that this is the perfect opportunity for the Supreme Court to resolve this question. So I hope they grant certiorari on this case. I think we do need some clarity because, as Professor Kerr says, if the interpretation of the 11th Circuit holds, and if there's this broad interpretation of the Computer Fraud and Abuse Act, then pretty much all of us have violated the Computer Fraud and Abuse Act. And I don't think
so?
So he talks about how it is a violation of Facebook's terms and services to falsify your location, which he did. And he admitted that in an affidavit to a court, mostly to make an academic point that, look, if you take this very rigid interpretation of the Computer Fraud and Abuse Act, where you are criminalizing mere violations of terms of service, which, as we just talked about in our previous segment, no one reads, then you're going to be criminalizing a lot of what we would probably deem to be normal online behavior. And what Kerr is saying, and I think what others have said, including the Electronic Frontier Foundation in a brief they sent to the court, is we don't want the Computer Fraud and Abuse Act to just be a very general crime where you can arrest and charge people for doing bad things on the internet. It was created for a very specific purpose, and that was to prevent hacking into systems in an unauthorized manner. And so I think there's sort of broad agreement in the privacy and civil liberties community that this interpretation that the 11th Circuit has and that they had in this Van Buren case could lead to some very, very problematic results. And I think that's why it's useful for the Supreme Court to weigh in.
Well, walk us through how this would play out if the Supreme Court decides to take it on.
If they grant certiorari, there would be...
Wait, is that a Latin term, Ben?
I'm going to Google it just to make sure. No, I'm not actually going to Google it. That is a Latin term.
All right, just
Although
checking.
I'm sure we're going to have users write in and be like, no, actually it's Italian. And
It's ancient Greek.
Yeah, I'll have to eat crow 2 weeks in a row. I don't know my classics, people. I'm sorry.
Okay.
So if they grant cert, then they would most likely hold oral arguments in the next Supreme Court session, which begins in October. Depending on the state of the world, that would probably be a live hearing. But we just found out that the Supreme Court is conducting, for the first time, online oral arguments in the next couple of months due to the COVID epidemic, which now, for the first time, we've mentioned that on this podcast. And,
we were so close.
We were so close to making it through.
Episode without mentioning it. Oh,
I know. We lose our prize.
Oh, well.
So, yeah, they would have the oral argument in the fall, and they would come to a decision that would have nationwide applicability sometime, I would guess probably early in the next year. But we're probably at least, 7 or 8 months from having any sort of resolution on this issue. And until we do, there are different rules depending on which, judicial circuit you happen to reside in. Here in Maryland, we are in the 4th Circuit Court of Appeals. If you happen to be in the 11th Circuit, that's where you would be subject to this interpretation. And that applies to Mr. Van Buren.
Now, from a legal point of view, help me understand here, when the Supreme Court makes a decision, how does that affect the decisions that the lower courts have made along the way? Is it retroactive if they decide that they don't go along with decisions other courts had made? Do those cases get revisited?
Generally, there's what's called a good faith exception. If law enforcement were following the prevailing law at the time when they charge somebody or make an arrest, then the Supreme Court would generally not retroactively vacate those charges. Now, as it applies to Mr. Van Buren himself, he would be the party in the case. So it would have the effect of vacating his conviction, and he would no longer be subject to whatever penalties he would suffer as a result of that violation. It would also mean that in the future, no matter which judicial circuit you were in, you could only be charged under the Computer Fraud and Abuse Act, or depending on what the Supreme Court says. If they decided that it had to be a traditional hack in order for there to be an offense under the CFAA, then that would be the rule for all future cases going forward, notwithstanding which judicial circuit you happen to reside in.
All right. Well, we will stay tuned on that one. Certainly interesting developments.
Yes. Yeah.
All right. We don't have a listener on the line this week, but we would love to hear your questions. If you have one, you can call in at 410-618-3720. That's 410-618-3720. You can also email us your question to caveat@thecyberwire.com. Coming up next, my conversation with Dmitry Alperovich. He is the co-founder and former CTO at CrowdStrike, and we will be discussing the recently published Cybersecurity Solarium report. But first, a word from our sponsors. And now, a word from our sponsor, SpyCloud, the cybercrime analytics leader. SpyCloud disrupts cybercrime by telling you what criminals know about your business and your customers, so you can take action to prevent ransomware, session hijacking, account takeover, and online fraud. SpyCloud constantly recaptures and analyzes new data from the criminal underground, including credentials, session cookies, and PII siphoned from malware-infected devices. With knowledge of the specific exposed data criminals have in hand from InfoStealer malware on managed and unmanaged devices, security teams can respond with a more efficient and effective process called post-infection remediation that fits seamlessly into existing incident response frameworks. Get SpyCloud's post-infection remediation guide outlining the 7 steps for preventing a malware infection from becoming a full-blown ransomware incident. Visit spycloud.com/cyberwire. That's spycloud.com/cyberwire. And we thank SpyCloud for sponsoring our show. And we are back. Ben recently had the pleasure of a very interesting conversation with Dmitry Alperovich. He is the co-founder and former CTO at CrowdStrike. He recently left CrowdStrike and he started a nonpartisan, nonprofit policy accelerator. And the focus of our conversation is the recently published Cybersecurity Solarium report. Here's my conversation with Dmitry Alperovich.
Well, the most important thing about the Solarium Commission and why it's different from so many other commissions that we have seen in this space, probably dozens upon dozens over the years, is that this was a commission that was organized by Congress, involving congressional members, and most importantly, doing its work for Congress itself. And many of the very thorny issues that we face in the policy space in cyber actually do require legislative fixes. And that's why it's so important to have had Congress's buy-in and indeed their interest in this from the very beginning. And that is why in many ways the other commissions have failed, because they were not really including congressional members from the get-go as the Solarium Commission has done, and not focused on specific legislative language and proposals as the staff is now working on with members of Congress. So that's what makes it very different. Some of the recommendations, of course, have been around for years. The commission members themselves have publicly stated that their goal was not necessarily to come up with radically new ideas, but to survey the landscape and figure out what was out there that was useful to leverage in order to move the ball forward. But there are a number of key concepts that I think are actually pretty important that the commission has highlighted. And the way I think about the problem of cybersecurity, at least on the defensive side, is really in three different areas. The first area is how do we protect the government itself, certainly the civilian.gov networks. And in fact, this is an area that gets often the least amount of attention in these reports and congressional oversight hearings, which is a huge mistake. From my perspective, the number one responsibility of the U.S. government is to protect itself. Before the U.S. government starts telling the private sector what it should do, it really should stop living in the glass house, where its own cybersecurity is literally much worse than most private sector networks. And we need to take care of that first and foremost. I think the vision for solving that is, at least the one that I have, is a pretty ambitious one. And I understand why the commission couldn't adopt that wholesale. But the thing that they came up with, which I really like, is the idea that you strengthen the power of CISA, this new agency that was formed in the last legislation that came about a year ago, and giving it actually the authority to hunt continuously across .gov networks, which will be a significant step forward in, one, clarifying their responsibilities, because right now CISA is a cybersecurity agency that is actually not, for the most part, doing the cybersecurity of the U.S. government. It is doing it from a sort of an advisor perspective, but not having actual operational responsibility. And I think moving it towards having some operational skin in the game is a good thing for both CISA and for the rest of the federal government. So I think that recommendation is a really, really good one, because it will actually give us ability to understand which adversaries are now on those networks, give us a sense of how they're getting in so we can learn from that experience and focus on, first and foremost, kicking them out, but secondly, on how do we shore up those networks to make it more difficult for them to come back. So really loving that recommendation. There's a second one that's sort of a corollary to that, which is empowering of the Defense Department and more specifically Cyber Command to continuously hunt across the .mil networks, the U.S. military networks. Similar principle where we need to understand which threat actors are already inside our sensitive networks, and giving really the authority to Cyber Command to bypass sort of the entrenched bureaucracy of different combatant commands, services, and others to really empower them to continuously hunt in those networks. I think both of those agencies, CISA on the civilian side and U.S. Cyber Command on the military side, will need to evolve further over the years, where they would actually need to be given responsibility to provide operational security for those networks, their respective networks, beyond just hunting. So being actually responsible for protecting them going forward, that's a huge change and a huge responsibility that will take many, many years to implement. But that's the model effectively that we're starting to see in other countries, where there is a centralization of cybersecurity expertise within the government and responsibility and authority as well. So those were the two that were focused on the government. On the private sector side, I'm actually a contrarian where I believe that we actually now know how to do cybersecurity well. And some of the best companies out there, certainly the big platform companies, the Googles of the world, the Microsofts, and many others are doing really, really well in defending their networks every single day against the most sophisticated adversaries, nation states, and organized criminal groups that are trying to infiltrate those networks. So the issue is not necessarily about sort of having Manhattan projects, if you will, of what do we do and how do we come up with new capabilities. The capabilities exist. The really good companies are well ahead of everyone else in understanding how to leverage them and operationalizing them. What we need to do is to make sure that everyone else, at least in terms of our critical infrastructure and other important businesses, are going to be on the same level. And for that, I do think we need some regulation. I think it needs to be lightweight and non-prescriptive. I'm not a fan, particularly in this area, of regulations that are overly prescriptive of, you shall patch, you shall adopt two-factor, or any of those recommendations, which on the face of it may seem sensible, but actually may be the wrong thing to do for a particular business. For example, if you're in the industrial control system space, patching may be literally the worst thing for you to do because patches have literally taken down more infrastructure than any piece of malware in that space. So you want to be really, really careful about how you patch. It doesn't mean you shouldn't, but it means that you should not be rushing to do it either. And whenever you're doing something, whether it's patching, whether it's two-factor, it, by definition, because resources are constrained, means you're not doing something else. And I would much rather have companies figure out themselves what is the order of priority that they need to have to apply some of these recommendations versus having the government dictate for them without the knowledge of their specific operational requirements, resourcing requirements, and so forth. But what I think the regulation should do is have accountability be placed on the boards of these companies and their CEOs to take cybersecurity seriously, to hold their own internal security teams accountable, and really focus on outcomes versus prescriptive plans that companies should implement. So one of the recommendations that I really, really loved in the commission was this 4.4.4 section, which says that the commission recommends amending the Sarbanes-Oxley Act, which is the act that was put in place after the Enron scandals in the early 2000s to regulate public companies better. And they recommend to amend that act to include some cybersecurity reporting requirements. And what I'd love to see, the section is a little bit vague on what it is that they actually want to have in the Sarbanes-Oxley Act, but I think the idea is right to at least start with public companies, which are regulated, of course, by the SEC, is to tell them, start tracking certain metrics. The way I'd love to see it is that they track them internally without even having to report them to the government. Because if you're reporting to the government, as we've seen, government security is not the best, and you don't necessarily want the government making it worse by having attackers break into government networks, steal that data, and then figure out who's doing well and not, and use that essentially as a target list. So I would love for companies to track that internally, focus on outcomes. One of the metrics that I've been talking about for years with boards of directors and companies and getting really, really good reception is what I call the 1-10-60 rule, which is one that measures speed of detection, speed of investigation, speed of response, where the best companies try to strive for detecting an intrusion on average in 1 minute, investigating in 10 minutes, and then responding and remediating it in 1 hour. Not everyone necessarily needs to be at that level, so people shouldn't be focusing on the numbers themselves as much as focusing on the model of tracking their speed of detection, speed of investigation, speed of response, and trying to optimize that. And if you're tracking that on a quarterly basis, if you're setting goals around those types of metrics and reporting them to the board, then the board has visibility in how well you're actually doing, how fast you are at detecting threats and responding to them. And the nice thing about requiring companies, at least public companies, to track those internal outcome-driven metrics is that if there is a breach, if there is a consequential event, inevitably nowadays you have lawsuits that are launched around those types of events. And in the event of a lawsuit, those metrics will be discoverable by the other side. And they'll be able to take a look at them and say, well, wait a second, they continuously miss on their own internal set goals around those metrics. Was the board aware on a quarterly basis and still did nothing in response? So there's a clear case of negligence here. Or perhaps they set goals that were too lenient compared to what the rest of the industry was setting, And again, the board was negligent. So it's a way to get the board to focus, one, on outcomes, to hold them accountable through potential litigation that may result coming out of a breach and negligence claims, and get them to not necessarily focus on technical details of how they should be securing them, but getting them to focus, again, on holding security teams accountable. Just like most members of the board are not experts in sales, but every single one of them that I've met certainly understands whether a company made their quarterly earnings numbers or not. Very, very simple and black and white sort of calculation of here's a number, did we make it or did we not make it? And then holding companies' leadership accountable for those results. We need the same sort of accountability in the cybersecurity space. And too often, when I've been in board meetings with huge public companies, Fortune 500 companies, and I've witnessed presentations by CISOs, oftentimes it's a laundry list of projects they're working on, and I'm looking at board members and they're on their phones, not paying attention because their eyes are just glazing over all the technical mumbo jumbo, and it's just not productive. Instead, they should be focused on talking about strategy and talking about the outcomes that they're achieving and what goals they're setting for themselves.
Now, in terms of urgency here, what do you suppose is a realistic timeline for rolling out some of these policies?
As I mentioned, the great thing here is that the commission included members of Congress, but more importantly, the two co-chairs of the commission, Mike Gallagher, who's a phenomenal congressman on the House side from Wisconsin, and Senator Angus King, also very well-versed in those issues on the Senate side. As the two co-chairs, they're now sponsoring legislation this year. Now, we'll see what happens with the COVID response that may slow things down. But they're very anxious to take some of those recommendations, not the whole laundry list of hundreds that, or almost 100 that the commission put together, but the most important ones from their perspective, and pushing them forward. One of the things that they are well aware of is that some of those recommendations can easily slide into what's called the NDAA, the National Defense Authorization Act, which has to pass every single year, which funds the military. So there's no way that Congress can't not pass that legislation. So if they can slide some of those recommendations into the NDAA, we can actually get a bill this year and take effect in the new fiscal year. We'll have to see how the pandemic crisis actually impacts this. The nice thing about cyber is that it is still a relatively bipartisan issue. And almost every year, if you look at the last 5 or 6 years, we've had some sort of cyber bill pass in Congress, which may surprise people given that nothing else really has much of a chance to pass. But on these issues, there is a great deal of urgency. There is a great deal of willingness on both Republicans and Democrats to do something. And the great thing about the commission is that you had staff literally not just write these high-level recommendations, but they're now working on specific legislative language, working with lawyers that they can give to staff in Congress and say, here you go, slide this into the bill, and let's get things moving.
Were there any areas where you feel as though they missed the mark, where they came up short?
Well, I think some of the recommendations in terms of some of the bureaucratic changes that they recommended, I think are probably not the right ones at this point in time. Creating new agencies or new bureaucratic positions, I don't think necessarily will solve the problem and will simply slow us down just by the nature of the fact how long it takes to stand up a new bureaucratic organization and for it to find its legs and really get things moving. So I could see some of those recommendations sort of, if you're starting with a blank slate, would make sense, but we're not. We've got a very urgent problem that we need to solve right now. You go to war with the army you have, as Don Rumsfeld once said, and we've got to leverage the resources we have to try to address this as quickly as possible. Some of those recommendations may make sense 5 or 10 years from now as we improve the situation and can start looking at how should we be reorganized for the future. But I don't think they make a lot of sense right now. The one that I thought was really, really good and the one that they sort of highlighted at the very beginning was on election security, obviously very timely this year. And they rightly called out the most urgent thing that we need to do in elections is making sure that there is a verifiable, auditable, paper-based voting systems in every precinct, county, and state in this country. And unfortunately, we still have states, including counties and battleground states, that don't have paper-based records in their voting systems. And if you want to ensure that voters have trust in the election systems, you just absolutely have to have that. And it was good to see that called out, and specifically calling on the Election Assistance Commission to receive additional funding to support states and localities to purchase that equipment.
All right, interesting conversation. What do you think, Ben?
So first of all, another huge get for the Caveat podcast. And I want to thank Dimitri for participating in the interview. It was very interesting, and it was a good summary of the Solarium Commission report. I would suggest that people read the executive summary of the report. It's 22 pages, which is long for an executive summary, but it does do a good job of delving into the issues that the commission looked at. He made a couple really interesting points. On the public sector side, I think having some sort of centralized agencies, including ones that already exist, like the Cybersecurity and Infrastructure Security Agency, be coordinating agencies for cybersecurity purposes is extremely important. We can do that in a way where there's proper congressional oversight, but having a centralized entity, is something that I think will improve coordination among federal government agencies and with the states. On the private sector, he seemed to say that, and maybe this is sort of contrary to public belief, but the private sector generally knows what it's doing in terms of protecting its own network. They're good at what they do. And we don't want any sort of federal entity to pass down to these private entities on tablets, this is exactly what you should do. You should patch this. You should do that. Keeping the advice general and allowing those private entities to act with speed and agility based on their current circumstances, I think is something that is also crucially important. And then election security, which I'm glad you guys talked about. It's obviously a big problem this year. We're in a presidential election, particularly when we might have a lot of people who are voting by mail or voting absentee. It can be difficult to keep a paper trail. That's why I'm glad he sort of mentioned that as a major area of concern. But it was a fascinating interview, and I definitely encourage people. I'm being realistic. I know you're not going to read the whole Cyberspace Solarium Commission report unless you're nerds like us. But I think the executive summary is well worth your time.
Now, a word from our sponsor, the Johns Hopkins University Information Security Institute, currently seeking qualified applicants for its innovative Master of Science in Security Informatics degree program. Study alongside world-class interdisciplinary experts and gain unparalleled educational, research, and professional experience in information security and assurance. Interested U.S. citizens should consider the National Science Foundation's CyberCore Scholarship for Service program, which covers tuition and a $6,000 annual professional development allowance, as well as providing a $37,000 additional annual stipend. Apply for the scholarship and the fall semester by March 1st. Learn more at cs.jhu.edu/MSSI. The Caveat podcast is proudly produced in Maryland at the startup studios of Data Tribe, where they're co-building the next generation of cybersecurity teams and technologies. Our thanks to the University of Maryland Center for Health and Homeland Security for their participation. You can learn more at mdchhs.com. Our coordinating producers are Kelsey Bond and Jennifer Iben. Our executive editor is Peter Kilpie. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.